I sat at my laptop staring at the results of my experiment, and my hands were shaking. I had just sent the exact same resume to 20 companies, same skills, same experience, same qualifications. The only difference, one version showed I was 28 years old, the other showed I was 48. The 28-year-old version got callbacks from 8 companies within 48 hours. The 48-year-old version, my actual age, got 0, not 1. The computer systems screening applications weren't just rejecting me because I was unqualified. They were rejecting me because I was too old. And they were doing it to thousands of people, maybe hundreds of thousands, without any human ever looking at our resumes. I had the proof right there on my screen. Data doesn't lie. The AI hiring systems that nearly every major company now uses were systematically discriminating against anyone over 40. And I was going to expose every single one of them, but I'm getting ahead of myself. Let me start from the beginning. My name is Michelle Thompson. I'm 48 years old, and until 8 months ago, I was a senior data analyst at a tech company in Atlanta called Data Vision Solutions. I had worked there for 6 years. I was good at my job, really good. My performance reviews were excellent. I had led projects that saved the company millions of dollars. I mentored junior analysts. I was on track for a promotion to director level. Then the layoffs came. It was October 2025. The CEO sent a company-wide email at 9 a.m. on a Tuesday. Subject line, organizational restructuring. I knew before I even opened it what was coming. The company had been struggling financially. Revenue was down. Several major clients had left. There had been whispers about layoffs for weeks. The email was corporate speak for "we're firing a lot of people." Terms like right-sizing and strategic workforce optimization and aligning our resources with business priorities. By noon, 20% of the company was gone, including me. My manager called me into a conference room. HR was there with a folder. They told me my position was being eliminated, handed me a severance package, 3 months' salary, gave me 30 minutes to pack my desk and leave the building. I had been there 6 years. 30 minutes to pack up and go. I wasn't angry. Exactly. Layoffs happen. The company was struggling. I understood the business reality. But I also wasn't worried. I'm a data analyst with over 20 years of experience. I have skills that are in high demand. I know Python, R, SQL, Tableau, Power BI. I've worked with machine learning models, predictive analytics, data visualization. I have a master's degree in statistics from Georgia Tech. I figured I'd find a new job within a month, maybe 2 at most. I was wrong. I started applying to jobs the next week, updated my resume, polished my LinkedIn profile, started searching on Indeed, LinkedIn Jobs, Glassdoor. There were plenty of openings. Data analyst positions, senior analyst roles, even some director-level jobs. Companies were hiring. The demand was clearly there. I started applying carefully at first, targeting jobs that seemed like perfect fits, customizing my resume for each position, writing thoughtful cover letters. I applied to 5 jobs in the first week, then 10 more the second week. Nothing. No callbacks, no interview requests, not even rejection emails, just silence. I thought maybe my resume wasn't getting through the applicant tracking systems, so I optimized it, added more keywords, reformatted to make sure the systems could read it properly.
Applied to 15 more jobs.
Still nothing. By December, I had applied to 73 positions. I was getting rejection emails now, but they were all automated. Thank you for your interest. We've decided to move forward with other candidates. Most of the rejections came within hours of submitting my application, sometimes within minutes. No human was reading my resume. I knew that. These companies all used AI screening systems, software that automatically reviews applications and decides which candidates get passed to human recruiters. I had been rejected 73 times by computer systems before any person ever saw my qualifications. By January 2026, I was getting desperate. My severance was running out. I had savings, but they wouldn't last forever. I had a mortgage, bills. My daughter was in college. I was helping pay her tuition. I needed a job. I started applying to everything. Jobs I was overqualified for, jobs that paid less than what I had made, jobs in other cities. I wasn't being picky anymore. I applied to another 40 jobs in January, got rejected from 38. The other two never even sent rejection emails, just ghosted me completely. By mid-February, I had applied to 147 positions. 147. And I had received exactly 0 interview requests. I sat in my home office one night in February looking at my spreadsheet of applications. I'm a data analyst. Of course, I had a spreadsheet tracking everything: job title, company, date applied, date rejected, salary range, required qualifications. I stared at that spreadsheet and something clicked in my brain. I'm a data analyst. This is a data problem. There's a pattern here, and I can find it. Most people who get rejected from 147 jobs would probably think, I'm doing something wrong. My resume isn't good enough. I'm not qualified. Maybe I should retrain. Maybe I should give up on this career. But I knew my qualifications were solid. I knew I was good at this work. And I knew that getting rejected within minutes or hours meant no human had actually reviewed my application, which meant the problem wasn't me. It was the system screening me out. And if it was a systems problem, I could analyze it. I started by looking at what these companies all had in common. Every single one used applicant tracking systems. Most used the same few vendors: Workday, Greenhouse, iSIMS, SAP SuccessFactors. These systems use AI to automatically screen resumes. They scan for keywords, evaluate qualifications, assess fit for the role. Then they rank candidates and only pass the top-ranked ones to human recruiters. It's efficient. When you're getting hundreds or thousands of applications for a single job, you can't have humans read every resume. I understood the business logic, but these systems aren't neutral. They're trained on data, historical data about who got hired in the past. And if that historical data contains biases, the AI learns those biases and perpetuates them. I had read articles about this, studies showing AI hiring tools discriminating against women, against people with ethnic names, against people from certain universities, but I hadn't seen much research on age discrimination. And that's when the thought hit me. What if these systems are screening me out because of my age? I'm 48. I have over 20 years of experience. My resume makes it obvious I'm not a recent graduate. What if the AI was using that information to automatically reject me? It seemed crazy. Age discrimination is illegal. Companies know that. They wouldn't deliberately program their systems to discriminate based on age, but these AI systems don't work through deliberate programming. They work by learning patterns from data. If companies have historically hired younger candidates, the AI might learn that younger equals better, even though no one explicitly told it to think that way. I needed to test this theory. I decided to run an experiment. I created 2 versions of my resume. They were identical in every meaningful way. Same skills, same experience, same education, same job history, same accomplishments. The only difference, the dates. Resume showed my college graduation year as 2023. That would make me appear to be about 28 years old, 4 years after graduating with a bachelor's degree, assuming I went to grad school after. Resume B showed my actual college graduation year, 1999, along with my actual work history spanning back to 2004. I kept everything else identical: same job titles, same descriptions of responsibilities and achievements. I just changed the time frames to make resume A appear to be from a younger person with the same qualifications compressed into fewer years. Then I found 20 job postings for senior data analyst positions, all at different companies, all using major applicant tracking systems with AI screening. I applied to each job twice. Once using resume A, appearing to be 28 years old. Once using resume B, my actual age of 48. I used slightly different email addresses so the systems wouldn't flag them as duplicates, but otherwise the applications were identical. Then I waited. The results came in fast. Within 24 hours, resume E, the one showing me as 28 years old, had received email responses from 6 companies. Thank you for applying. We'd like to schedule a phone interview. Resume B, showing my actual age, received automated rejections from 4 companies. The other 16 never responded at all. By 48 hours, Resume A had 8 interview requests out of 20 applications. Resume B had 0. I sat there staring at my inbox, feeling a strange mix of emotions. Vindication, because my theory was right. Anger, because this confirmed what I suspected. The systems were discriminating. and a sick feeling in my stomach, because this meant I hadn't been doing anything wrong. I had been qualified for all those jobs. I just never had a chance because a computer decided I was too old before any human ever saw my resume. But I needed more data. 20 applications wasn't a large enough sample size. Maybe it was a coincidence. Maybe those specific companies just happened to need someone with less experience for budget reasons. I ran the experiment again. Different 20 companies, same methodology, same results. Resume appearing 28, 7 interview requests. Resume B appearing 48, 0. I ran it a third time. Resume A, 9 interview requests. Resume B, 1 interview request, which was later canceled.
60 total applications. Resume received 24 interview requests, a 40% callback rate.
Resume B received 1, which was canceled less than 2%. The data was undeniable. When companies thought I was 28, they wanted to interview me. When they knew I was 48, they didn't. Same qualifications. Same experience. The only variable was age. This was systematic age discrimination, happening at scale, carried out by AI systems that millions of companies were using. And it wasn't just affecting me. If these systems were discriminating against me, they were discriminating against everyone over 40,000 of qualified people being screened out of jobs they were perfectly capable of doing just because of their age. I needed to understand how this was happening. The AI wasn't looking at my resume and seeing a date of birth field. There wasn't one. So how was it determining my age? I started analyzing what information the systems could access. College graduation dates. That's an obvious one. If you graduated in 1999, you're probably around 45 to 50 years old now. Years of experience. My resume showed 20 plus years of work history. That's another signal. Date ranges for jobs held. If your first job started in 2004, the system can do the math. But there were subtler signals too. The AI systems were sophisticated. They could detect patterns. For example, the technology I mentioned having experience with. My resume listed experience with older programming languages and tools alongside newer ones. Someone who learned SAS in 2005 and Python in 2015 has a different profile than someone who only knows Python. The types of roles I had held. Senior positions that spanned 10-year periods suggested someone with deep experience, meaning someone who had been working a long time. Even the way I wrote about my accomplishments. My descriptions referenced business contexts and technologies from different eras, and AI trained on enough resumes could probably recognize those patterns. The systems were using all of these signals: college graduation dates, years of experience, employment date ranges, technologies mentioned as proxies for age, and then they were using age as a factor in deciding who to interview. It was brilliant, in an awful way. No one had programmed the AI to discriminate based on age explicitly. But the AI had learned from historical hiring data that companies tended to hire younger candidates for certain roles, so it replicated that pattern. The people who built these systems probably had no idea this was happening. Or maybe they did and didn't care. Or maybe they knew but figured it was defensible because the AI was just optimizing for the candidates most likely to be successful based on historical data. But it was still discrimination, and it was illegal. The Age Discrimination in Employment Act, ADA, prohibits employment discrimination against anyone 40 or older. Companies can't refuse to hire someone because of their age. But that's exactly what was happening, just with computers doing it instead of humans. I took screenshots of everything. The job postings I had applied to, the 2 versions of my resume, the interview request for resume A, the rejections or silence for resume B. I created a detailed spreadsheet documenting all 60 test applications. Company name, job title, which resume version, response received, timestamp. The data showed a clear statistically significant pattern. Resume A, appearing younger, had a 40% callback rate. Resume B, appearing older, had less than 2%. That's not a coincidence. That's systematic discrimination. I also documented my 147 legitimate applications from my actual job search, the ones where I had used my real resume with my real age, 147 applications, 0 interviews. But I knew from my experiment that if those same companies had thought I was 28 instead of 48, I would have gotten around 60 interview requests based on the 40% callback rate. 60 job interviews I never got because AI systems decided I was too old. I had the evidence. Now I needed to figure out what to do with it. I researched what legal options existed, age discrimination lawsuits, EEOC complaints, class action possibilities. I also started reading news articles about AI discrimination cases. There was one that kept coming up, Mobley v. Workday. Derek Mobley was a black woman in his 40s who had applied to over 100 jobs through Workday's applicant tracking system and was rejected from all of them. He sued Workday, claiming their AI tools discriminated based on race, age, and disability. The case was still ongoing, but it had survived motions to dismiss. A federal judge had ruled that Workday could be held liable for discrimination, even though they weren't the employer, they were the vendor providing the AI screening tools. That case had been certified as a class action in May 2025, meaning thousands of other rejected applicants over 40 could join. I looked up the law firm handling it, read about the legal theory they were using, disparate impact discrimination. Disparate impact means that even if there's no intentional discrimination, a policy or practice that disproportionately harms a protected group can still be illegal if it's not justified by business necessity. The AI systems didn't have a setting that said reject applicants over 40, but if they were rejecting people over 40 at much higher rates than younger applicants with similar qualifications, that was disparate impact. And my experiment proved exactly that. I also found information about new laws. Illinois had just passed legislation in 2026 requiring companies to notify job applicants when AI was being used to make hiring decisions. The law also prohibited AI from being used in ways that resulted in discrimination. Other states were considering similar laws. The legal landscape was shifting, but enforcement was still weak. Companies were using these AI systems with very little oversight. Most people who got rejected never knew AI was involved. They just thought they weren't qualified. I had been fortunate. I had the skills to test the system and prove what was happening. But how many other people over 40 were being screened out and had no idea why? I thought about all the people I knew who had been laid off in their 40s or 50s and struggled to find work, friends who had impressive resumes and years of experience but couldn't get interviews, people who blamed themselves, thought they were obsolete, felt like failures. What if they weren't failures at all? What if they were just being discriminated against by AI systems that had learned to prefer younger candidates? This was bigger than just me. This was affecting millions of people. I needed to report this. But to who? I could file an EEOC complaint, but that would take years to investigate, and I'd only be addressing my individual case. I could contact the law firm handling the Mobley v. Workday case and see if I could join that lawsuit. Or I could go public, contact journalists, make this story public so people understood what was happening. I decided to do all three. First, I filed a formal complaint with the Equal Employment Opportunity Commission. I included my detailed documentation, the experimental results showing age-based disparate treatment, the list of 147 companies that had rejected me, copies of the different resume versions I had tested. I wrote a detailed narrative explaining my methodology and findings. I provided statistical analysis showing that the difference in callback rates was statistically significant and could not be explained by chance. The EEOC acknowledges receipt of my complaint within a week. They assigned it a case number and told me it would be investigated. Second, I contacted the law firm handling Mobley v. Workday. I explained my situation and my experimental findings. They were very interested. They asked me to send all my documentation. A partner at the firm called me the next week. She explained that they were building a class action against multiple AI vendors, not just Workday. My case could potentially become part of a broader lawsuit targeting the entire industry of AI hiring tools. She asked if I would be willing to be a named plaintiff, to have my name attached to the lawsuit, to potentially testify, to be public about what I had experienced. I thought about it for a few days. Being a plaintiff in a class action lawsuit meant exposure. It meant my name would be in court documents. Companies I might want to work for in the future would be able to Google me and see that I had sued over hiring discrimination. But I also thought about the 60 interviews I should have gotten, but didn't. The months of unemployment, the fear that I wouldn't be able to support my family, the feeling of worthlessness when you apply to nearly 150 jobs and get rejected from all of them. And I thought about everyone else going through the same thing who didn't have the skills to prove what was happening to them. I told the lawyer yes, I would be a named plaintiff. Third, I started contacting journalists. I found reporters who had covered AI discrimination and the Mobley case. I sent them emails with a brief summary of my story and my findings. Several responded immediately. A reporter from The Atlantic wanted to write a feature story. A tech journalist from Wired was interested. NPR wanted to do an interview for their tech policy show. I chose to start with NPR because they had the largest audience and I trusted them to handle the story responsibly. The interview was scheduled for early March. They sent a producer to my house in Atlanta. We sat in my home office, the same room where I had run my experiments, and I walked them through everything. I showed them the data, explained how I had set up the test, showed them the dramatic difference in callback rates. The reporter asked tough questions. How do you know it was age and not something else? Maybe the companies preferred candidates with less experience because they were hiring for junior roles. I had anticipated that. I applied to senior analyst and director level positions. These were roles requiring 10 plus years of experience, and the job descriptions explicitly stated they wanted someone with extensive experience. The only thing that changed between my two resume versions was the apparent age. Everything else, including the amount of experience shown, was identical. Could it be that companies preferred the candidates who appeared to have more diverse recent experience, given that the compressed timeline made it look like you had done more in less time? Possibly, but that's still age discrimination. If an AI system is rejecting people because their experience is spread over 20 years instead of 6, and using that as a proxy for age, that's illegal. The reporter nodded. She got it. The NPR story aired 2 weeks later. It was a 7-minute segment on their tech and society show. They interviewed me, an employment lawyer who specialized in discrimination cases, and a computer science professor who studied AI bias. The professor explained how AI systems can learn to discriminate even when they're not explicitly programmed to. These algorithms are trained on historical hiring data. If companies have historically hired younger people for certain roles, the AI learns that pattern and replicates it. It's a feedback loop that perpetuates existing biases. The employment lawyer noted, "What makes this particularly insidious is that it's invisible. A rejected job applicant has no idea that AI was involved in the decision. They just get a generic rejection email. They have no way to know that they were screened out because of their age." The story ended with my conclusion. I'm a data analyst. I know how to work with data and systems. That's the only reason I was able to prove what was happening. But there are millions of people over 40 who are being discriminated against by these systems and have no idea. They just think they're not good enough. That's wrong, and it needs to stop. The response was immediate and overwhelming. Within 24 hours of the NPR story airing, my inbox was flooded. Emails from people all over the country. Dozens at first, then hundreds. I'm 52, and I've applied to 200 jobs in the last year. I never thought about age discrimination. But now I'm wondering. I got laid off at 46 and couldn't find work for 18 months. Everyone told me I was overqualified. Was it really age discrimination? I'm a software engineer with 25 years of experience. Companies keep rejecting me within hours of applying. I thought my skills were outdated, but maybe it's not about skills at all. Story after story, people in their 40s, 50s, even 60s, experienced professionals with impressive careers who couldn't get interviews despite being qualified. Many of them had assumed it was their fault, that they needed to update their skills, or accept lower-level positions, or that they were just too expensive for companies to hire. It hadn't occurred to them that they were being screened out by computer systems before any human even looked at their qualifications. I read every email, hundreds of them, and a pattern emerged that was even worse than I had realized. This wasn't just affecting a few people, this was industry-wide, systematic discrimination happening at massive scale. The law firm handling the Mobley case contacted me again. They had been flooded too. After the NPR story, over 3,000 people had reached out saying they wanted to join the class action lawsuit. 3,000 people who believed they had been discriminated against by AI hiring systems. The lawyer told me they were expanding the case. It was no longer just about Workday. They were targeting multiple AI vendor companies. Workday, HireVue, iSims, Greenhouse, any company providing AI screening tools that showed evidence of age discrimination. She asked if I would be willing to share my experimental data and methodology with other people who wanted to test whether they were being discriminated against. I said yes. I created a detailed guide explaining how to conduct the same experiment I had run, how to create two versions of your resume that were identical except for age-related information, how to apply to the same jobs using both versions, how to document the results. I posted it online. Within a week, over 500 people had downloaded it and were running their own tests. The results started coming in. A 50-year-old marketing director in Boston ran the experiment with 20 applications. Her younger resume got 6 callbacks, her real resume got 0. A 43-year-old accountant in Denver tested 30 companies. Younger version, 11 callbacks. Real version, 1 callback. Real version, 1 callback. A 55-year-old project manager in Dallas tested 15 jobs. Younger version, 5 callbacks. Real version, 0. The pattern was consistent across industries, locations, and job types. Resumes that appeared to be from younger candidates got significantly more callbacks than identical resumes from older candidates. People started sharing their results publicly on LinkedIn, on Twitter, in online forums for job seekers. The story was going viral. Major news outlets picked it up. The Washington Post ran a front-page story, AI hiring tools accused of widespread age discrimination. The New York Times tech section did a deep dive, the algorithm that decides who gets a job and who doesn't. 60 Minutes contacted me. They wanted to do a segment on AI discrimination in hiring. I agreed to the interview. It aired in April 2026. The segment was powerful. They interviewed me, showing my experimental data. They interviewed other people over 40 who had struggled to find work after being laid off. They interviewed the lawyers building the class action case. And crucially, they interviewed a whistleblower, a former employee of one of the major AI hiring tool companies. The whistleblower's face was obscured and voice disguised, but their testimony was damning. We knew the system was filtering out older candidates at higher rates, the whistleblower said. We could see it in the data. But the company didn't want to fix it because clients liked that the AI was screening so many people out. It made the recruiters' jobs easier. They didn't care if qualified people were being rejected. They just wanted a smaller pool to review. The 60 Minutes correspondent asked, "Did anyone raise concerns about age discrimination?" "Yes, several engineers flagged it. We had internal discussions about whether we should adjust the algorithm, but the decision from leadership was that as long as we weren't explicitly using age as a factor, it was legally defensible. They said we were just using historical hiring patterns, and if those patterns happened to favor younger candidates, that was a reflection of what clients wanted, not discrimination on our part." "But that is discrimination," the correspondent said. "I know, that's why I left the company." That interview changed everything. It wasn't just job seekers claiming discrimination anymore. It was an insider confirming that the companies building these AI tools knew they were discriminating and chose not to fix it. The story exploded. Stock prices for the AI hiring tool companies dropped. Several faced shareholder lawsuits alleging the companies had concealed the discrimination risk. The EEOC announced they were launching a formal investigation into AI hiring discrimination, not just individual complaints like mine, but a systematic investigation across the industry. The Department of Labor announced they would be reviewing federal contractors' use of AI hiring tools to ensure compliance with anti-discrimination laws. Several states, California, New York, Illinois, Colorado, announced they were considering legislation to regulate AI in hiring. And the class action lawsuit was growing. Over 10,000 people had now joined as plaintiffs, claiming they had been discriminated against by AI hiring systems. The law firm asked me to be one of the lead plaintiffs representing the class, along with 2 other people, a 50-year-old woman who was a former HR director and had been rejected from over 200 jobs, and a 62-year-old man who was a software engineer with 40 years of experience. We became the public faces of the case. We did interviews together, testified at legislative hearings, spoke at conferences about employment discrimination. It was surreal. 8 months earlier, I had been sitting in my home office, unemployed and desperate, wondering what I was doing wrong. Now I was on national television talking about systematic age discrimination in AI hiring systems, but the companies weren't backing down without a fight. The AI vendors issued statements denying discrimination. They claimed their systems were neutral, that they didn't use age as a factor, that any disparities in outcomes were due to legitimate differences in qualifications. Workday's statement said, "Our AI tools are designed to help companies find the most qualified candidates based on skills, experience, and job requirements. We do not discriminate based on age or any other protected characteristic. Any suggestion otherwise is false and misleading." HireVue said, "Our algorithms are regularly audited for bias. We are committed to fair hiring practices and comply with all applicable laws." But their denials rang hollow, especially after the whistleblower testimony. The lawyers in our case filed motions to compel discovery. They wanted access to the company's internal documents, emails, and algorithm details to prove the systems were discriminating. The companies fought it. They claimed their algorithms were proprietary trade secrets that couldn't be disclosed. The judge wasn't sympathetic. In a ruling in May 2026, she wrote, "If these companies are selling tools that make employment decisions affecting millions of people, they cannot hide behind claims of trade secrecy to avoid scrutiny of whether those tools comply with civil rights laws. The plaintiffs are entitled to discovery of how these systems work and what data they use." The companies were ordered to turn over internal documents and technical details about their AI systems. What we found in discovery was even worse than we had suspected. Internal emails showed executives at multiple companies discussing the age issue. They knew their systems were screening out older candidates at disproportionate rates. One email from an executive at a major AI vendor said, "Our clients prefer younger candidates for most roles. The algorithm is just giving them what they want. If we change it to be age neutral, we'll lose business because they'll say we're sending them too many overqualified candidates." Another email from a product manager, "We need to be careful about how we document this. We can't say we're filtering by age, but we can use proxies, years since degree, total years of experience, technology recency. Those correlate strongly with age and give clients the results they want." These weren't rogue employees, these were senior leaders at the companies explicitly discussing how to discriminate without getting caught. The internal data was damning too. We got access to aggregated statistics from the AI systems. They showed that candidates over 40 were screened out at rates 3 to 5 times higher than candidates under 40 with equivalent qualifications.
For some roles, the disparity was even worse. For software engineer positions, candidates over 45 had less than a 5% pass rate through the AI screening, compared to a 35% pass rate for candidates under 30.
Same job title, same required qualifications, massively different outcomes based on age. One particularly revealing document was an internal audit that one company had conducted in 2024. Their own data scientists had flagged that the AI was showing significant age bias. The audit recommended adjusting the algorithm to reduce the bias, but the company had rejected the recommendation. An executive wrote in response, "Our clients are not complaining about the current results. Making changes risks disrupting a system that is working well from a business perspective. Let's table this for now." In other words, we know we're discriminating, but it's profitable, so we're going to keep doing it. The discovery materials were filed with the court. They became public record. Journalists pored over them. The headlines were brutal. AI hiring company knew it was discriminating against older workers, emails show. Internal documents revealed deliberate age bias in job screening algorithms. Executives discussed how to hide age discrimination in AI tools. The company's stock prices dropped further. Several faced criminal referrals for potential fraud and civil rights violations, but the most important development was the class certification. In June 2026, the judge granted full class certification to our lawsuit. That meant everyone over 40 who had been rejected by these AI screening systems over the past 3 years could potentially be part of the case. The lawyers estimated the class could include over 200,000 people. 200,000 people who had been screened out of jobs because AI systems decided they were too old. The potential damages were enormous. If each person could prove they lost even one job opportunity due to discrimination, the compensatory damages alone could be billions of dollars. Add in punitive damages for the company's knowing and willful discrimination, and the total liability could be catastrophic for the AI vendors. Settlement negotiations began immediately. The companies didn't want this going to trial. The evidence was too damaging. The public sentiment was too strongly against them, and the potential jury verdict was too unpredictable. But they also didn't want to admit wrongdoing. They wanted to settle without acknowledging that their systems had discriminated. Our lawyers refused. We wanted an admission. We wanted the companies to acknowledge what they had done, not just for the money, but for the principle. The negotiations dragged on for weeks. Meanwhile, the regulatory pressure was building. The EEOC issued new guidance on AI in hiring. They made clear that employers and AI vendors could both be held liable for discrimination, even if the discrimination was unintentional. The guidance stated, the use of algorithmic decision-making tools does not insulate employers from responsibility for discrimination. If an AI system produces discriminatory outcomes, both the employer using it and the vendor providing it can be held liable under federal civil rights laws. Several states passed laws regulating AI in hiring. Illinois' law required companies to notify applicants when AI was being used and to conduct annual bias audits. California's law went further, requiring companies to provide explanations to rejected candidates about what factors the AI considered. New York City passed the strictest law requiring third-party audits of all AI hiring tools and prohibiting their use if they showed evidence of bias against any protected group. Compliance was going to be expensive and complicated for the AI vendors. Their entire business model was under threat, and the class action wasn't the only lawsuit they were facing. Individual plaintiffs were filing separate cases. State attorneys general were launching investigations. The Department of Justice was reportedly considering criminal charges for civil rights violations. The companies were under siege from all sides. In August 2026, the first settlement was announced. HireVue agreed to pay $350 million to settle claims that its video interview AI tool discriminated based on age, race, and disability. The settlement included several important provisions beyond the money. HireVue had to discontinue use of its most problematic AI features, specifically the tools that analyzed facial expressions and voice patterns, which had been shown to discriminate against older candidates and people with disabilities. They had to conduct annual third-party bias audits of all their AI tools and make the results public. They had to notify all job applicants when AI was being used to evaluate them. And crucially, they had to admit that their systems had unintentionally produced discriminatory outcomes and commit to preventing discrimination in the future. It wasn't a full admission of intentional discrimination, but it was an acknowledgement that their tools had harmed people. The settlement sent shockwaves through the industry. If HireVue had to pay $350 million, what would the other companies face? Workday settled 2 weeks later, $500 million, with similar terms: discontinuation of certain AI features, mandatory audits, transparency requirements, and an acknowledgement that their systems had produced discriminatory outcomes. The other defendants started negotiating seriously. But our case, the main class action covering 200,000 people, was still ongoing. We hadn't settled yet because we were holding out for better terms. We wanted more than money. We wanted structural changes to the entire industry. Our demands included all AI hiring tools must be tested for bias before being sold to companies. Annual third-party audits must be conducted and made publicly available. Applicants must be notified when AI is used and must be given the option to request human review if they're rejected. Companies using AI tools must track outcomes by age, race, gender, and other protected characteristics to identify potential discrimination. Any AI tool showing evidence of discrimination must be immediately taken off the market. The AI vendors resisted these demands. They said they were too expensive, too burdensome, that they would destroy the entire AI hiring industry. Our lawyers responded, good. If the industry can't exist without discriminating, it shouldn't exist at all. The negotiations continued through September and October. Meanwhile, I had finally gotten a job. A company in Atlanta, a data analytics firm, had reached out after seeing me on 60 Minutes. They said they were impressed by my work exposing the AI discrimination and thought my analytical skills would be valuable to their team. They made me an offer, senior data analyst position, same level I had been at before the layoff, good salary, full benefits. I accepted immediately. It was ironic. I had applied to 147 jobs and been rejected from all of them when I was just another anonymous applicant in the AI screening system. But once I became publicly known for exposing that system, companies wanted to hire me. It proved the point, really. I had always been qualified. The AI had just never given me a chance. Starting the new job was strange. I was grateful to be employed again, to have income and health insurance and a sense of purpose. But I was also acutely aware of the absurdity. I had gotten this job because I was famous for being discriminated against. What about everyone else who was equally qualified but didn't have that platform? I thought about the 3,000 people who had initially contacted the law firm after the NPR story, the 10,000 who had joined the class action, the 200,000 who were potentially affected. Most of them still hadn't found jobs. They were still being screened out by AI systems every day, despite all the publicity and legal action. The settlements with HireVue and Workday were significant, but they hadn't fundamentally changed the system yet. Other companies were still using AI tools that discriminated. And even the companies that had settled were just adjusting their algorithms. There was no guarantee the new versions wouldn't discriminate in different ways. Real change would require more than lawsuits and settlements. It would require regulatory oversight, enforcement, and a fundamental shift in how companies thought about hiring. But we had made progress, more progress than I ever thought possible when I first ran my experiment back in February. In November 2026, the remaining defendants in our class action case agreed to settle. The total settlement amount across all companies, $2.4 billion. $2.4 billion. It was the largest employment discrimination settlement in history. The money would be distributed among the 200,000 class members. Not everyone would get the same amount. It would depend on how many jobs they had applied to and been rejected from, how long they had been unemployed, and other factors. But for many people, it would be significant compensation, tens of thousands of dollars. For some, over 100,000. More importantly, the settlement included all the structural changes we had demanded. All AI hiring tools would now be subject to mandatory bias testing and annual audits. Results of those audits would be publicly available, so job seekers could see which systems had been tested for fairness. Applicants would be notified when AI was used in the screening process. Anyone rejected by an AI system would have the right to request human review. Companies using AI tools would be required to track demographic outcomes and report them to the EEOC annually. Any AI tool showing evidence of discrimination would have to be taken off the market until the bias was corrected. It wasn't perfect. There would still be ways for companies to game the system or for bias to creep back in. But it was real, enforceable change. The AI hiring industry would never be the same. The settlement was announced in a press conference in December. I stood alongside the other lead plaintiffs, our lawyers, and representatives from employment advocacy groups. The lead attorney gave a statement. This settlement represents a victory not just for the 200,000 people who were discriminated against, but for everyone who believes that employment decisions should be based on qualifications, not on age or other protected characteristics. We have forced an entire industry to change its practices and have established clear legal precedent that AI systems cannot be used to discriminate, even unintentionally. I gave a brief statement too. 8 months ago, I was unemployed and desperate, wondering why I couldn't get a single interview despite being qualified for the jobs I applied to. I discovered it was because AI systems were screening me out based on my age before any human ever saw my resume. That discovery led to this lawsuit, and now we've secured real change. But this isn't over. We need continued vigilance to make sure these systems are actually fair, not just in theory, but in practice. And we need to remember that behind every statistic is a real person whose career and livelihood was affected. The press conference was covered extensively. The settlement was the lead story on the evening news, and the response from the public was overwhelmingly positive. People felt like justice had been served, like the system for once had worked. But I also heard from people who felt the settlement didn't go far enough. $2.4 billion sounds like a lot, but divided among 200,000 people, it's only $12,000 each on average. That doesn't compensate for months or years of unemployment. The structural changes are good, but what about all the companies that aren't part of this lawsuit? They can still use discriminatory AI tools. This only addresses age discrimination. What about race, gender, disability? AI systems discriminate in all kinds of ways, and most people can't prove it. Those criticisms were valid. The settlement was significant, but it wasn't comprehensive. It addressed one specific type of discrimination by specific companies. There were still gaps, but it was progress, real, measurable progress. And it had started with one unemployed data analyst running an experiment because he was frustrated by rejection emails. That was the thing I kept coming back to. I hadn't set out to launch a historic class action lawsuit or change an entire industry. I had just wanted to understand why I couldn't get a job interview. But by using my skills to analyze the problem, by documenting what I found, and by having the courage to go public with it, I had sparked something much bigger than myself. In January 2027, I was invited to testify before Congress again. This time, it was the Senate Committee on Labor and Employment. They were considering federal legislation to regulate AI in hiring. My testimony would help inform their deliberations. I prepared carefully. I wanted to make sure lawmakers understood both the technical aspects of how AI discrimination worked and the human impact. I told them about my 147 rejected applications, about the experiment I ran, about the 200,000 people who had been affected. But I also told them about the emails I had received, the stories of people who had given up on finding work because they thought they were unemployable, people who had drained their savings, lost their homes, fallen into depression because they couldn't understand why no one would hire them. These aren't just statistics, I said. These are real people whose lives were upended by systems that judged them before any human ever saw their qualifications. We need federal protections to ensure this doesn't keep happening. The senators asked pointed questions. Some were skeptical about regulating AI too heavily. They worried it would stifle innovation. I responded, innovation is important, but not at the expense of civil rights. If the only way AI hiring tools can work is by discriminating against people over 40, then those tools shouldn't exist. We don't allow companies to discriminate just because it's more efficient. The same principle should apply to AI. Other senators asked about enforcement. How would we make sure companies actually complied with regulations? The same way we enforce any civil rights law, I said, through EEOC investigations, private lawsuits, and penalties significant enough to make discrimination more expensive than compliance. The settlement we achieved, $2.4 billion, sent a clear message to the industry. Discrimination is costly. Companies will change their behavior when the alternative is that expensive. The hearing lasted 3 hours. When it was over, several senators thanked me for my testimony and said it had been illuminating. I didn't know if federal legislation would actually pass. The political environment was complicated, and there were powerful industry lobbies fighting against regulation. But the conversation had shifted. AI in hiring was now a national issue. People understood the risks, and there was momentum for change. As I flew back to Atlanta after the hearing, I reflected on everything that had happened over the past year. I had lost my job, struggled with unemployment, discovered systematic discrimination, become a plaintiff in a historic lawsuit, helped secure a $2.4 billion settlement, testified before Congress. It had been exhausting and stressful and at times overwhelming, but it had also been meaningful. I had taken my anger and frustration and channeled it into something productive. I had used my skills to expose injustice, and I had been part of achieving real change. The AI hiring industry would never be the same. Companies would have to be more careful, more transparent, more accountable. It wasn't perfect. Discrimination wouldn't disappear overnight. AI systems would find new ways to show bias, and we'd have to keep fighting. But we had proven something important. These systems could be challenged, data could reveal their biases, legal action could force change, and ordinary people, people like me who just wanted a fair chance at a job, could take on massive corporations and win. The months after the congressional hearing brought changes I hadn't anticipated. The settlement money started being distributed in March 2027. I received $43,000 as one of the lead plaintiffs' compensation for the 8 months I had been unemployed and the 147 jobs I had been rejected from. $43,000 couldn't replace the stress of those months, the fear that I wouldn't be able to support my family, or the damage to my confidence. But it was acknowledgement, validation that what had happened to me was wrong and that I deserved compensation. More importantly, the 200,000 other class members received their payments. The amounts varied widely, from a few $1,000s for people who had applied to a handful of jobs to over 200,000 for people who had been unemployed for years and applied to hundreds of positions. I heard from many of them. Emails thanking me for starting the case, letters describing how the money had helped them pay off debt, cover medical bills, or stay in their homes while they continued looking for work. One woman wrote, "I'm 60 years old and had been unemployed for 3 years. I thought my career was over. The settlement gave me enough money to survive while I kept searching, and I finally found a job last month. Thank you for not giving up. Those messages meant more to me than the money. But the real measure of success wasn't the settlement. It was whether the industry actually changed. The mandatory bias audits started being published in April. Companies that sold AI hiring tools were now required to test them annually and report the results publicly. The first round of results was eye-opening. Several major AI vendors disclosed that their systems had shown significant bias against candidates over 40. Just as we had suspected, the problem wasn't limited to the companies we had sued. It was industry-wide. But now it was public information. Job seekers could see which systems had been tested and which ones had failed the bias tests. Several companies pulled their AI hiring tools from the market entirely. They couldn't fix the bias, so they discontinued the products. Others redesigned their algorithms. They removed features that had been shown to correlate with age, like analyzing gaps in employment history or penalizing candidates who had too many years of experience. The new generation of AI hiring tools was far from perfect, but they were better than what had existed before, and they were being watched closely. Watchdog organizations emerged specifically to monitor AI hiring systems. One group, called Fair Hiring Tech, began publishing annual reports grading different AI vendors on their bias testing results and transparency practices. Job seekers started using those reports to avoid applying to companies that used poorly rated AI systems. And companies started caring about their ratings because candidates were making decisions based on them. The market was creating accountability. Meanwhile, my own career had taken an unexpected turn. The data analytics firm that had hired me promoted me 6 months in. I was now director of analytics, leading a team of 8 people. But I was also being asked to consult on AI bias issues. Companies wanted help auditing their hiring systems. Law firms wanted expert witnesses for discrimination cases. Advocacy groups wanted advisors who understood both the technical and legal aspects. I started doing that work on the side. Evenings and weekends, I would review AI systems for companies trying to comply with the new regulations. I would analyze their hiring data to identify potential bias. I would recommend changes to their algorithms or their processes. It was work I found deeply satisfying. I was using my skills to prevent the kind of discrimination I had experienced. Every bias system I helped fix meant fewer people would be screened out unfairly. By summer 2027, I was doing so much consulting work that I had to make a decision: stay at my full-time job or go independent. I chose independence. I left the analytics firm on good terms and launched my own consultancy, Thompson Fairness Analytics. My mission was simple: help companies build AI systems that didn't discriminate. The business grew faster than I expected. Within 3 months, I had more clients than I could handle alone. I hired 2 employees, both data scientists who had been laid off in their late 40s and had struggled to find work. They understood the problem personally, which made them excellent at identifying bias in systems.
We were building something meaningful, not just a business, but a movement toward fairer hiring practices.
And the impact extended beyond just the clients we worked with directly. Other people who had been part of the class action lawsuit were using their experiences to create change too. The 50-year-old former HR director became an advocate for age diversity in the workplace. She started a nonprofit that helped companies understand the value of older workers and trained HR departments on avoiding age bias. The 62-year-old software engineer launched a coding bootcamp specifically for people over 40 who wanted to update their skills. He proved that older workers could learn new technologies just as well as younger ones. They just needed access and opportunity. Dozens of others became activists, consultants, trainers, or simply more vocal advocates in their own workplaces. The lawsuit had done more than win money. It had created a network of people committed to fighting age discrimination. The legislative changes continued too. By the end of 2027, 15 states had passed laws regulating AI in hiring. The laws varied in their specifics, but most included requirements for bias testing, transparency, and the right to human review. Federal legislation was still stalled in Congress, but the patchwork of state laws was creating de facto national standards. Companies that operated in multiple states had to comply with the strictest states' requirements, which effectively meant adopting those practices everywhere. The EEOC had also stepped up enforcement. They conducted audits of major employers' hiring practices and found several companies still using AI tools that showed evidence of discrimination despite the settlement and new regulations. Those companies faced hefty fines and were required to stop using the bias systems immediately. The message was clear. The government was serious about enforcing these laws. But perhaps the most significant change was cultural. Age discrimination in hiring had always existed, but it had been invisible and deniable. Companies could claim they just happened to hire younger candidates because they were better fits or more dynamic. Now it was out in the open. People understood that AI systems could discriminate. Journalists reported on it, regulators scrutinized it, job seekers were aware of it, and knew to look for signs of bias. The conversation had fundamentally shifted. I saw evidence of this at a conference I attended in November 2027. It was a human resources technology conference where companies showcased their hiring tools. Every single vendor at the conference prominently displayed their bias testing results. They competed on who had the best fairness scores. They marketed themselves as certified age bias-free or independently audited for discrimination. 2 years earlier, none of these companies even acknowledged that bias was an issue. Now it was a major selling point. The industry had changed because the market demanded it. And the market demanded it because people like me had exposed the problem and refused to accept the industry's denials. That realization that individual action could lead to systemic change stayed with me. I thought about all the people who had emailed me after the NPR story, the ones who said they had been struggling with unemployment and had blamed themselves, who thought they were obsolete or not good enough. I thought about the emails I received now, people thanking me for giving them hope, for proving that the system was broken, not them. One email in particular stuck with me. It was from a 53-year-old woman who had been unemployed for 2 years after being laid off from a marketing job. She wrote, "I was ready to give up. I thought I was too old, that the world had moved on without me. But your story made me realize I wasn't the problem. I started testing companies the way you did, and I found that when I removed my graduation year from my resume, I started getting callbacks. I have a job interview next week. For the first time in 2 years, I have hope." That was the real victory. Not the settlement money or the regulatory changes, important as those were. The real victory was giving people their dignity back, showing them they weren't failures, they had been discriminated against, and that was wrong, and now there were tools to fight back. As 2027 drew to a close, I reflected on everything that had happened since that October morning in 2025 when I got laid off. I had been devastated, lost, wondering if my career was over at 48. But instead of accepting the rejections, I had investigated. I had used my skills as a data analyst to understand what was happening. I had documented the discrimination systematically. I had gone public even though it was risky. I had joined a lawsuit and fought for change. And because of that, hundreds of thousands of people had been compensated for discrimination. An entire industry had been forced to reform. Laws had been passed. Cultural attitudes had shifted. None of that would have happened if I had just accepted the 147th rejection email and given up. The lesson, the one I tried to share every time I spoke publicly, was simple. Documentation defeats discrimination. When you're being treated unfairly, especially by systems that claim to be neutral, you need evidence. You need data. You need to prove what's happening, not just assert it. I had been able to do that because I had the skills, but the methodology I used wasn't complicated. Anyone could replicate it, create test cases, document the results, look for patterns, and once you have evidence, you have power. Power to file complaints, power to sue, power to go public, power to demand change. That's what I wanted people to understand. You're not powerless against these systems. They seem overwhelming. Big companies, complex algorithms, legal protections for proprietary methods. But data reveals truth. And truth, when made public, creates accountability. The AI hiring discrimination case had proven that one person with a spreadsheet and the determination to test a theory had sparked a movement that changed an industry. There would be new battles. AI would evolve. Companies would find new ways to screen candidates. Bias would creep back in through different mechanisms. But now we knew what to look for. We had tools. We had legal precedent. We had a community of people watching and ready to fight. And we had proven that change was possible. In early 2028, I was invited to give a keynote speech at a tech ethics conference. The topic was how individual action creates systemic change. I told my story, the layoff, the rejections, the experiment, the lawsuit, the settlement. but I ended with a message about power. When I started this, I felt powerless. I said I was just an unemployed woman in his late 40s getting rejected from jobs by computers. I had no money, no platform, no connections. What could I possibly do against billion-dollar companies using cutting-edge technology to screen me out? But I had something they didn't count on. I had expertise. I knew how to analyze data. I knew how to test hypotheses. I knew how to document evidence. And I had something else. I refused to accept that the system was fair just because it was automated. I questioned it. I tested it. I proved it was broken. That's available to everyone. You don't need to be a data scientist to document patterns. You don't need to be a lawyer to file a complaint. You don't need to be famous to go public with what you've discovered. You just need to pay attention, keep records, and have the courage to say, this isn't right and I can prove it. Systems change when enough people refuse to accept them as inevitable. My case helped change AI hiring, but there are hundreds of other systems that need to change in healthcare, in finance, in education, in housing, in criminal justice. Those changes will come from people like you, people who notice something's wrong, who document it, who speak up even when it's risky. Don't wait for someone else to fix the problem. You have more power than you think.
The speech got a standing ovation, but more importantly, it sparked conversations.
People came up to me afterward with stories of systems they thought were discriminating against them. AI tools in lending, algorithms in health insurance, automated decision-making in housing applications. Some of them asked for advice on how to test whether they were being treated unfairly. I walked them through the methodology, create equivalent test cases, document outcomes, look for patterns. I didn't know if any of them would follow through. Testing systems takes time and courage. Fighting them takes even more. But if even a few of them did, there would be more cases like mine. More evidence, more lawsuits, more change. That's how systemic change happens. Not through one heroic individual, but through many people, each doing their part, each using their skills and their voice and their determination to expose injustice and demand better. I had been one of those people, and because I had refused to stay silent about what I discovered, the world was slightly fairer for hundreds of thousands of others. That was enough. That was worth the risk, the stress, the uncertainty. And it was a reminder that anyone, any one of us, can be the person who sparks the next wave of change. All it takes is the courage to question systems that claim to be fair, the discipline to document what you find, and the determination to fight even when the odds seem impossible. If you've ever been rejected by a system that didn't give you a fair chance, if you've ever suspected discrimination but didn't know how to prove it, if you've ever felt powerless against algorithms and corporations that seem too big to challenge, remember this: data defeats lies, documentation defeats discrimination, and one person with evidence and determination can change everything. Subscribe for daily stories where expertise defeats unfairness, where systematic documentation brings down corrupt systems, and where ordinary people armed with spreadsheets and courage can force billion-dollar industries to change. Stories where AI discrimination gets exposed, where evidence wins against denials, and where the quiet work of analyzing patterns sparks movements that transform entire industries. New story, every day. The Quiet Reckoning.